Our today's topic is law and its sources. This is the sequence of the lecture. First, we will learn that what's the objective of the study of law, and then the introduction. Then we will define it, and we will see that how different scholars and political scientists have described law and what are the features and nature of law. What is a law? How it developed and how it came into being. And the first one, that in our daily routine, in our daily life, we follow various types of laws. That's why it is necessary to understand the meaning, nature, and sources of law. This is the basic objective of this study of law. The introduction, that law is the most important feature of the modern state. As in an organized polity, the law is the basic things that put things together. In an organized society, in an organized polity, a law is the most important feature. And laws, which are commonly known as sets of uniform principles, operate in all fields of human activity from science to society. So laws are uniform, they are single, and it covers every aspect of human activity, from your family life to social. Definition and meaning of law. So first, the term law, that is derived from the word lag, which means fixed or uniform. So laws are always fixed and uniform. There is no flexibility, there is no discrimination, and they are equally applied to everyone. So equality matters in law. And it means rules of behavior which will be uniform for all. John Austin says that command of the sovereign is called a law. So the definition of Austin, so he says that the command or the order or the laws of the sovereign, they are called a law. And it may be a okay, there are certain features and nature of laws which explain that what is a law. The number one is that a law expresses the will of the state. Law is considered to be the expression of the absolute sovereignty of the state. Rules and regulation of the state is called law. So basically, state expresses its will through laws, and these laws and the expression of laws is given by a sovereign or by a state, and these rules and regulations are called law. And laws are always made by the government, and government is basically the authority which works on behalf of the state. Like sovereignty belongs to state, and government enjoys this authority this sovereignty on the behalf of state. Government has three organs: the legislature, executive, and judiciary. Legislative organ of the government makes the laws. Executive organ of the government implements and enforces the laws, and judicial organ of the government interprets the laws and grants punishment to those who violate the law. Thus, a law is made by the government and reflects the will of the state. So, government, it works with three organs. The number one is the legislature, whose sole responsibility is to make laws, and the executive organ, who is actually known as the government. The real, authority lies with the executive organ of the state, and they got the authority to execute the laws and enforce the laws. And the judicial organ, it interprets the law and it grants punishment to those who violate the law. Laws are universal. It means laws are universally applicable to all. It means the rules of law. A law must apply to all citizens equally and treat them similarly. That equal application of law, and every citizen must be treated equally according to law. Equality before the laws and equal protection of laws to all. Like, the protection of law must be given equally to everyone. Like, the penalty for committing a narcotic offense, such as carrying prohibited drugs on one's person, is the same for all Indians, or from Bollywood actor to common man. Like Salman Khan or Sanjay Dutt, or they have been caught many times with some narcotics, but they've been treated equally because laws are equally applied to everyone. So laws are universally applicable, and they are applicable without any discrimination. And that's why the basic feature of law is that they are uniformed. And a law must be, number five is, a law must be constitutionally valid. Government makes the laws within the framework of constitutions, and laws are precisely written down. Constitution is basically the supreme body of principles, and it helps the legislature to make the laws within the framework of the constitution. Like in Pakistan, no law can be made against the fundamental rights of the people. If any law made against these basic fundamental rights, so that will stand null and void. Same like if any law made against the basic ideology of Pakistan or basic ideology of Islam, so that law will stand null and void as well. And laws are precisely written down. So that will help the people to understand the laws and follow the laws. And there is a coercive authority behind law. There is a person who forces you to obey the law. Violation of law invites punishment by the state. Like police force, identify a violation of the act and judicially punish the accused. Thus, laws are backed up by a system of coercion and punishment. So there is a coercive authority. So the police force actually it identifies the misconduct, the crime, a violation of the law, and it takes the case to the judiciary, and judiciary will punish the accused. So the coercion and the punishment, these are basically the system which are the coercive measures, and the authority actually exercises its authority, this power, through law. So whenever you see a policeman, so you actually start obeying the laws, because the police force got the authority to identify a violation of the crime. The supreme purpose of law is welfare of the people, and number 8 is people give obedience to the law as it has the validity and sanctions of the state, and laws are basically the will of the state, so that's why people give obedience to law. And laws are compulsory, not optional. All individuals are bound by the law of the state, and no one can be excused for breaking a law on the grounds of ignorance. So that's why a very famous dictum is that ignorance of law is no excuse, and it is mandatory for every citizen, a responsible citizen, to be aware of the laws of the state. And individuals and associations are supposed to know the law of the state. So citizens must be aware of the laws of the state. Sources of law. Sources of law mean various factors that contribute to determine the content of law. A law is made by the government and expresses the will of the state. However, a government does not take decisions in isolation. Like they will sit in their office and they will make laws. No, they are supposed to have a very clear understanding of the environment and the condition that require a law. So the government, it does not take decisions in isolation or make laws in isolation. So there exist various non-governmental factors that influence the creation of law. The number 1 is customs. It is the first source of law, and it existed before the formal organized society. Before state, the people were following customs, and customs are the earliest form of regulations of human society. They were obeyed during earlier times before the political state or modern state system or organized societies, and for their social utility, and later on due to habit. So initially they were feeling okay with these social customs, and later it became an habit and they starting following these customs. And customs are valued and respected by the people, and violation of customs leads to public displeasure. लोग रसूम और रिवाज को बड़ी इज्जत देते हैं, एहतराम देते हैं, और अगर कोई रस्म रिवाज से हट के कोई कर दे कुछ, तो फिर क्या होता है कि लोग उस पर बड़ा गुस्सा होते हैं, ये हमारे रस्म में रिवाज, हमारी रसूम रिवाज में नहीं था, ये हमारी रिवायात नहीं है ऐसी, तो फिर हमने ऐसा क्यों किया। So after the emergence of state, customs slowly gave way to laws, and the state understood the utilitarian value of customs. So the state initially enforced only the customary laws. So people were be very feeling very pleasure to follow these customary laws, and the government adopted it, and because the state understood that it is the utilitarian value is really important, and the government started enforcing the customary laws. And custom is not a law unless it is recognized by the. Number two is religion. In the primitive society, customs had religious sanctions. Every aspect of life was regulated by religion. People had faith in religion and therefore followed religious practice meticulously. Eventually, religious rules were translated into legal rules for controlling and regulating human behavior, as Muslim laws are based on the code of Holy Quran. So people, they were really pleased to follow the religious commandments and religious scientific commentaries. So there are writings of eminent jurists which contain important legal principles. And jurists collect and compare a lot of information. They study the existing legal system, find out the drawbacks in it, and suggest measures to reform it. So the experienced jurists, the experienced scholars, or the lawyers, sometimes they have a very close eye on different laws and their application. So they comment on those laws, and sometimes the existing legal system, and they find out the drawbacks in it and suggest the measures to reform it. And the lawyers and the judges, they both use the writing of these experts. When they are accepted by the judge, they become part of law. If a commentary of a jurist, so it is considered and accepted by a judge, so then it becomes a law because it gets the authority of a president. तो जब वो प्रेसिडेंट बन जाती है तो that is a law. Equity is basically the use of common sense by the judges. It means the principle of fairness and justice. So the judge basically does not decide a case on the basis of the existing law. The civil law becomes rigid and unrealistic. It gives rise to equity, because laws are always rigid and unrealistic, and then equity comes into play. When the judge finds that justice cannot be achieved with the help of existing law, he decides the case on the basis of fairness. And by doing this, precedent is set and it becomes the basis of new law. It is an informal method for making a new law or approving an old law, and it is the power of equity is basically the power of judiciary. Is the example is like अगर someone who just for the sake legislation. Legislature is the lawmaking body of the government, and today most of the laws are product of legislature. Lawmaking is the primary responsibility of the legislature, as Indian government and the Pakistani parliament and Indian parliament work as a lawmaking body. An ordinance to meet an emergency, the government issue ordinance. It is issued when the legislature is not in session. It is as effective as law. Very often the legislature converts an ordinance into a law. So ordinance, basically the government issues these ordinance when the legislature, the lawmaking organ of the government is not in session, and it requires uh, the laws are required urgently. So the government issues these ordinance, and these ordinance are not for a longer period of time. It is just for 3 to 4 months, and within 3 to 4 months, the it is obligatory on the government to get it passed through the parliament, through the legislation. So when it is passed by the legislature, then it becomes the law. And if it is not passed by the legislature, so it loses its power and it will not be considered a law anymore. And that's all. If you have any question, you can ask, please.